Hello, everyone, and thank you for joining us for our session, Been There, Done That, where we'll be hearing from some rising stars in family law about their first 5 years of practice. This session has been especially created for our Family Law Forum members, and our Family Law Forum is a new hub where we'll be sharing legal content and webinars so you can get your CPD points without having to leave your desk. I'll share a link to the registration page in the chat box. We are very lucky today be joined by three people who I consider to be great rising stars in the family law field. Firstly, Emma Shuttleworth, who's a Senior Associate at Barker, Stool and Winning, Georgia Burke, who's Special Counsel at Bruin Abrahams and Burkett, and Georgia Carroll, Director at Jacaranda Legal. My name is Dina Palethorpe, and I'm the Family Law Forum Coordinator here at LEAP. Before we go any further, I'd just like to take a moment to acknowledge the traditional custodians of the lands on which we're meeting today. For me, I'm dialing in from Sydney, so that's the Gadigal people of the Eora Nation. I pay my respects to all elders past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander people dialed in today. We will be taking questions as we go through, so if you do have any questions, please feel free to use the Q&A chat box and I'll put them to our presenters. But without further ado, I'll pass it over to them and we might start with Georgia Carroll.
Hi, I'm Georgia Carroll. I am a Director and Accredited Specialist in Family Law at Jacaranda Legal, which is a newly established firm by me and a colleague. Prior to that, I worked at a suburban firm specialising in family law, but prior to that had a little bit of experience across a range of other areas as well.
Okay, Georgia Burke.
Thanks, Dina, and lovely to be here with everyone today. As Dina has mentioned, I'm Special Counsel at Bruin Abrahams Burkett. I had my first 5 years of practice in Hobart, Tasmania, so a little bit of a different start in a smaller place before coming to the big city. I also like to be involved in other areas of the legal community. I'm on the Diversity and Inclusion Committee of the Law Society of New South Wales and a long-time member of the National Committee of Australian Lawyers for Human Rights.
Well, we're very glad to have you here in Sydney now.
Thanks, Dina.
Over to you, Emma.
My name is Emma Shuttleworth. I'm also an accredited specialist in family law. I'm currently at Barker, Stool and Winning. I cut my teeth in Parramatta as a baby lawyer, and I've been primarily practicing in Sydney for the past 7 years or so.
Okay, well, thank you all for joining us. So my first burning question is, what led you to a career in family law, and is it what you expected when you first started out? So Georgia Carroll, we might start with you.
Thanks, Dina. So I worked in a generalist firm during my university days. I then went through a clerkship in one of the city firms because I thought that's what everyone had to do. I was at one of those universities where that was what was in vogue and felt compelled to do the same as everybody else. I took that path, really enjoyed my experience as part of the clerkship and got the graduate offer and things like that. But felt a little bit conflicted with what I wanted in my career, my work-life balance and things like that. And one of the areas that I really enjoyed when doing the rotations was employment law. And people said to me, that is the family law of the corporate world. So I came back to my suburban firm that I'd been at prior and said, hey, do you mind if I switch areas and work in there? And literally the rest is history from there. So the reason I enjoy working in it is because of the people and the stories behind it all. So it's something that just felt right for me as like a value fit and something that I'm really passionate about.
Great, thanks for that. Georgia Burke.
Yeah, I have to credit my family law elective probably with being a lawyer at all. I really oscillated through uni as to whether I was going to utilise just law as an add-on with my arts degree to perhaps work in public policy or something government related, or whether I was going to practice. And after a really dry fourth year of really corporate subjects, some similar themes there to Georgia Carroll, I was really unsure as to whether I was going to be a practitioner, but doing family law as an elective alongside some other more practical subjects like evidence law made me think, yes, I think this is for me. There was a reason I started this at the beginning in first year. and that compelled me to seek out some work experience. I went for the, make yourself as small as possible and take up the quarter of an office in a firm until people forget that you don't actually work there method of employment, and that seemed to work out. And I was really lucky to have some fantastic early mentors who had a love of this crazy world that is family law and really instilled in me the passion for it and the people in it.
Emma, how about you?
In uni, I worked as a paralegal at a firm that did war veterans and war widows pension appeals in the AAT, which is the Administrative Appeals Tribunal back then. And that involved a bit of, like family law, it involved a bit of casework, but it also had appearances, but there are appearances before a member, so you didn't need to be admitted to do that. And then I did a clerkship in a multidisciplinary firm, put in my preferences, picked family law as my first preference and was lucky enough to get it. I liked family law. I liked the colour that was in it. I liked the fact that there was that mixture of that sort of casework, and then there was advocacy, court appearances, going to court. It wasn't just stuck behind a desk doing dry things. And it's pretty similar to what I expected, just as colourful. Sometimes I get surprised about the stories that come out of the cases and the clients that you meet, but it's definitely not dull.
And I guess, my reasons aren't as glamorous as any of yours, but I used to watch The Practice and Boston Legal as a child, and I thought, wow, that looks so interesting. And then Georgia Carroll, a bit like what you were saying, I like being with people and working with people, so that's what led me to family law. But I will move on to the next question now. Okay, so Georgia Carroll, what kind of court appearances can junior lawyers realistically expect to take on in their first few years, and how can they best prepare for them?
Until recently, I would have said divorce. So now you're looking at more mentions, briefing for interim hearings, sitting in on judgment deliveries, sitting in on other people's matters whenever and wherever you can. You learn so much from sitting in the back of the courtroom or sitting in whilst someone's dialed into a listing, and then working your way up to other things like conciliation conferences and family dispute resolution. How you can best prepare is know everything about the matter inside out. I was saying to the girls the other day when we were chatting about this presentation, I used to go to my first court listings for years, actually, and I probably should still do the same, but I don't. And I would know the date of birth of every person in that matter. Like, I would know whether that was born on a Tuesday or Wednesday. It was ridiculous, the level of preparation that I put in. But I think that is basically what you need to do in order to go and be as confident as you can in court, because there are so many unknowns as a junior lawyer. If you can be really in control of the facts in front of you and really across that, that's going to make you feel as comfortable as you possibly can in those situations.
Yeah, I definitely agree. Preparation is key, I think. So we might move on to the next question. What are some core skills every early career family lawyer should focus on developing? Emma, I might throw this one to you.
I would be saying not to rely too blindly on those sort of resources like the artificial intelligence forums and even precedents to an extent, because you don't want to undercut your own drafting ability and learning to do that drafting. And I would also be saying, no matter who's prepared your precedents, it could be the most impressive senior lawyer of all time. If you don't quite understand why an order is worded a certain way, or if it doesn't quite make sense to you, don't feel that you can't amend it, because if it's something you don't understand, you might have a difficult time arguing about the mechanics behind it at some point. And you also don't know how long that order has been there. It might have just been missed if it's got something that wasn't quite working properly or it hadn't been updated. And also, if you just blindly use precedents without ever amending them yourself and developing that drafting skill, you won't have the confidence to draft orders yourself blindly. And the amount of times you'll be sitting at a conciliation conference or sitting in a courtroom and you'll be put on the spot and told to draft something, and you won't be able to pull out your phone or your laptop and look for some copy paste thing to put it across. And it wouldn't look very impressive if you're in front of a client typing it into ChatGPT or something. So really, like, get yourself to do that. And it's also going to help you when you're amending other sides' orders to be understanding what changes you should be making and if there's any sneaky things there, if you've made yourself get that drafting skill instead of relying upon other precedent orders that have been drafted for you. And the other core skill I would say everyone should use is just picking up the phone. Sometimes one phone call can save 2 weeks of back and forth of correspondence. And it also is going to give you a little bit of not FaceTime, but phone time with the solicitor on the other side that might just make the matter a bit more enjoyable or be able to shortcut some of the things that could have been lost or misinterpreted in written communications.
Yeah, I think definitely picking up the phone. I remember being a junior solicitor and my principal telling me that it's something you don't want to do, but it actually saves you so much.
And even if someone seems awful in their correspondence, it might just be that they've got a difficult client taking a hard line, and it might just take that edge off it when you actually get to talk to the voice behind the mean and nasty letters.
And I think it is a bit difficult where we're having more virtual appearances. You haven't just got your opponent like down the other side of the court floor, you know, where you can just go have a chat to them. So picking up the phone is definitely key. Georgia Burke, do you have anything to add to that?
Yes, I think it ties in well, hopefully, with what Emma has had to say in relation to the use of precedents and drafting, but that is to always have your legislation or your rules in front of you when you're doing so. So whether you're drafting parenting orders, property orders, some kind of deed, a child support agreement, financial agreement, every time you're seeing a provision referred to in the legislation or the rules, you should be checking to see that that's correct. It's good for accuracy, which will improve your standing with your directors or principals, I'm sure, but it's also good for your instant recall. And this isn't something that just junior lawyers do. It's something that I still do, that our managing director does. So it is a great habit to get into and will set you up to avoid unnecessary mistakes. And look, I think the phone point is such a good one, and just something I'd add to that, which harks back to the court appearances question as well, I think, which is that don't forget that every time you open your mouth, it is advocacy. So it is tricky for junior lawyers at the moment because there isn't a divorce list. The subpoena list that probably a lot of us cut our teeth on early on, it doesn't exist. You don't get the opportunity to hang around at an in-person duty list. So find other ways to develop your advocacy, and picking up the phone and being able to clearly articulate a position in a friendly way, as we've said, it's the chance to cut through the noise, is a great chance to have that practice.
And George Carroll, we might flick to you now.
Thank you. I would just say one of the other really core skills is emotional intelligence and working on that, particularly as family lawyers, the clients that we're dealing with, the high stakes, the high emotions, and including that of the other side often. It's really important to just pay attention to everything around you and be really observant of how everyone is feeling, what the body language is doing, read the gaps between the words spoken, be curious. Ask questions, and don't just think that you know everything. But similarly, be confident as well where you can in the things that you know, and don't be afraid to learn, to hold your ground, or check in with the senior person if you think, no, you know what, I actually feel that this is the right position. Feel comfortable in holding that position, respectfully, of course, but if you're not sure, like Georgia Burke was saying, go back and check the rules, check the legislation, always have that up in front of you. But I think, yeah, the key skill other than that would just be to really work on that emotional intelligence side of things.
And I think particularly like just the reading the body language, that's so important. And we've just finished our advocacy series with Karen Shea, and she said the amount of time that solicitors are appearing in court and they're so nervous that they're looking at their notes or they're looking down. They're not looking at the judge. They're not seeing whether the judge is actually paying attention or wants them to move on. So I think that's very important as well. Okay, so on to the next question. What are some common mistakes that you see newer lawyers make, and how can they avoid them? Georgia Carroll.
So probably in contrast to what I just said about being confident, it's a fine balance, right? Don't shoot from the hip without any basis. My pet peeve in life is people that do that have these knee-jerk gut reactions to things, and they're like, that's right, I'm sticking with that, that's my line. If you are wrong, feel free to own that mistake. I think that's a really important, valuable skill. But firstly, try and not make that mistake. So if you're not sure, don't be afraid to simply say, I'll get back to you on that one. I think that's a really important lesson to learn very early, or just in fact, try to avoid that lesson entirely and take this advice.
I think it's knowing the bounds of what your knowledge is and where it's appropriate to actually like escalate something, to say, oh, let me talk to the partner. Oh, we need to talk to our expert on that, you know. And I was telling the girls my story of when I used to work for a judge. She said, it's not the known, it's not the things you know, it's not the things that you know that you don't know. It's the unknown unknown, the things that you don't even know that you don't know. So those are things to be cautious of. Emma, over to you.
I think one of the common mistakes that new lawyers, but not limited to new lawyers, I think it's a difficult thing at any stage of practice to get in the habit of avoiding, is chasing rabbits down holes. In this area of law, our clients are really driven by emotions, and it can be easy to get caught in to get caught in that tunnel vision that they're driving you towards. So I think each step of the way, you have to ask yourself before you send each letter, each email, draft any applications, is the point of this and what the client's asking me to ask going to help us achieve the ultimate outcome we want? Or is it just white noise? Because at the end of the day, that's what's really relevant. And you might have a client, and there's a million examples you could use, but they're just so upset. And one of the hardest things in their life at the moment is that their child keeps getting sent home with the red lunchbox and not the blue lunchbox. But sending letters back and forth every week on that is just not going to ultimately help them get the final orders they want. It's going to spend their money unnecessarily, and it's not going to foster any goodwill between them and their former partner as future co-parents. So, and there's other things like disclosure as well, where they'll keep hammering on about different bank statements and spending and things like that. So just keep asking yourself, is this actually going to impact the final outcome or help us get there? And if it's not, maybe have a hard conversation with your client and pull them back into line, because that sort of circular correspondence is just not going to assist anyone.
Georgia Burke, over to you.
On that theme of knowing where the bounds of your knowledge is or where your mistakes might lie, it's also, I think, not realizing sometimes where the knowledge baton passes to someone else. And that's tricky to learn, I think, as a junior lawyer, between yourself and your superior, your supervisor, your practice director, but also other professionals. So, you know, am I meant to understand this? Of course, we always want to understand precisely what we're doing, but can I get some help from an accountant? Does this knowledge really tag with them, where if I got some advice from an accountant, advice from another professional, that's going to help me do my job as a family lawyer. You're not expected to be all things to everyone, but you do need to know the bounds of that experience and when it's appropriate to bring in another expert, potentially from a related field.
Yeah, that's so important. Good point. Okay, so the next question is, how did you start contributing to case strategy as a junior, and what helped you contribute meaningfully to those conversations? So Georgia Carroll, we might flick to you.
So this is a really important part of any family lawyer's job. So when a client comes in and they tell you their story, you need to come up with a bit of a case theory, right? But instead of just going immediately to your principal or whoever's supervising you and saying, what do you think? Come, and this is for any question, come with the question and your set of answers. And it doesn't have to be the answer, but it has to be a range of options that you consider might be appropriate and the reasons why. So for example, you might come in and say, look, this is the question. Here's what I'm thinking. Option A, here's the pros and cons with it. This is the ramification. If this, then that. This is option B, similar. If this, then that. C, if this, then that. And this is why I think option C is the answer. What do you think? Not only does that build a better relationship and show off what you know to the person supervising you, it also builds your confidence in running through those scenarios, because then you're in a position to be able to run through them with your client and put them in a letter of advice, because that's part of our job as well. It also allows us to then do the education part to the client and the advisory part, and then to then provide those instructions. But for you, in having that conversation with your supervisor, more often than not, they're actually probably going to turn around to you when you've thought about it that deeply and gone, Yes, you're correct. Option C is the best strategy. However, a caveat to that is sometimes there isn't one direct, obvious solution to these things. So this is where it's actually a little bit of fun, and you can have a play around with the supervisor, and you can have a little bit of an argument about why B versus C, and you can have a play with that. So you build a lot of confidence in doing that, and it's a really good starting point for the development of case strategy.
Yeah, and it's good to be able to talk through why you're thinking what you're thinking and have those open conversations, because it's better to do it with your partner than, you know, when you're in court and trying to push that point in front of the judge. Georgia Burke, what's your take on this?
Sure. I mean, there is an aspect where it's time and files, and using all of those tools that George has spoken about. There is an element of, you begin with a little bit of instinct, and it's your job to grow that instinct. The challenge of being a young lawyer, a junior lawyer, is that you haven't seen matters through to their end. And look, some of our matters take years to make it to a final hearing, if they ever do. So are you going to see how that letter is utilised in cross-examination? You know, it might take you a long while to get there. So asking the right questions of those you're working around about this is really important in the early days. Those sit-down meetings, of course, grabbing time in your supervisor's office, important, but be sneaky about it as well. You know, if you go to the conference with counsel, your voice may not be welcome in asking direct questions in front of the client in your very early days, but ask them to your supervisor on the walk on the way back. Get them talking about the case, about what they're thinking, and take the chance to give your view and ask your questions in the course of some informal conversations. You'll get a lot out of it.
Emma, what's your take?
I started contributing to case strategy as a junior lawyer. I was rather immersed in it because I only worked with one other senior family lawyer. So I had a lot of free rein in terms of being able to do things. And it got to the point one day where I actually started doing her dictation. I started more like of a PA role. And it got to the point where letters were coming in and I could anticipate how she would respond to it. So I just started saying, can I have a go at responding? So just by being a junior lawyer and drafting letters and things like that, you're going to inadvertently be contributing to case strategy, because it'll be then taking you to the next step. But if you're not fortunate enough to be in such a small environment like I was, another good way to do it, aside from just doing the letters and then talking them through with whoever's signing off on them, would be to speak to the supervising partner on that case and see how they'd like to be utilised in terms of their availability to have those discussions. So it might be that they're someone that just wants you to block out time in their diary and you can just pop into their office. It might be you can just pick up the phone and have a chat to them about it, but do whatever is necessary to get that phone time or FaceTime with them, because just having a discussion about it, none of us can shut up, and we all like to then theorize the different way it's going to go. And we don't know the way it's going to go. So it is that sort of like hypothesizing about it. But even in a lunchroom, things like that, even if it's a partner that's not the partner on that matter, if you just give them that hypothetical, you're going to be inadvertently discussing case strategy and developing it. And it's the best way to do it is learning off those more senior lawyers.
Thanks for that. Okay, on to the next question. So how did you build your client base in the early stages of your career? And how did you build client trust when you're still developing confidence in your own legal skills and knowledge? Emma, let's start with you.
The first thing I would say is I feel like there's a lot of pressure put on young lawyers, you know, how you're going to build a client base. And it's a very important tool, but I wouldn't be putting too much pressure on yourself in your first year or so of practice, because you're simply not going to be pulling in big clients that frequently. The main way that I started to develop a client base for myself was from prior client referrals who had seen my work and thought I'd done a good job and were referring people that they knew. So it will come in time. But there are other ways you can do it anyway. But in terms of building the client trust when you still don't know what's going on, I think one of the most important things is just being upfront and honest with them. So if you don't know the answer to something, don't fudge your way through it, because clients can usually pick up if you're a bit uncertain about anything. And you also don't want to give the wrong answer. There's absolutely nothing wrong with saying it's a bit of a grey area of law. Look, let me do some research and come back to you. Or that law is current, the case law in that area is continuing to develop, continuing to change. Let me come back to you. Or even that you're going to speak to the supervising partner on their file and just talk them through some of the thoughts you're having before you come back to the client on it. And I think that that's a really important way to go, because it's just going to show them that you're putting in the time and the effort. And more importantly, you can sell yourself and say that the reason, you know, you're working on it is because you're a bit cheaper than maybe the senior partner is. So you're cheaper and you're more available than that senior partner. It's a way to kind of get the clients to want to speak to you, even though you might not have that legal knowledge and experience of the senior partner. So I don't think there's any harm in saying that you're going to confer with that senior partner, because that's who they want involved in their matter already. And it's just getting them in that doorway when they might not be able to get that phone time with that partner that you can get. So I think that that's the main things about it. Just be upfront and honest. And then otherwise, just show them common courtesy. It's a very high pressure environment working in family law, so don't put unnecessary pressure on yourself. If they're saying that this email has to go out that afternoon and you don't have the capacity to do it, tell them you don't have the capacity to do it. Don't be bullied into saying it will go out and then not having the ability to send it out that day and getting them offside because you just weren't able to do what you said you would do. You'd be better to undersell and overachieve. Tell them that you're not going to be able to get to it till early next week. And if it goes out the following day, they're going to be happy. So just do what you're going to say you're going to do and never put any deadlines on yourself that might be unrealistic, because they don't appreciate it.
And I think just going back to your previous point about if you know you don't know the answer, try to get them off the phone and then either do the research or go talk to your partner. I recall having very sort of high needs client who just wanted to talk constantly and would go round and round in circles. It was like, I need to talk to the partner. Let's end it there. So I'm not billing you anymore, and I'll come back to you on that as soon as I can. So I think that's also, if you know that you don't know. Yeah.
We're also like the queens of spin as well. You can always spin it and say, look, you know, I don't want you to be stuck on the phone while I just do this quick research. Let me save you some money. I'll get off. It'll be quicker for me to do it. And then I'll just email you the answer. And then they're going to think, oh, look, you know, she's being conscious of my costs, when really you just had no idea where to begin. So there's nothing wrong with, within the realms of reason, putting a little spin on it that's going to be appreciated by the client.
Definitely. Sorry. All right, on to the next question. This is a really important one. How did you get comfortable with the commercial side of private practice, like the billables, the time recording, and the cost discussions with clients? Specifically on the point of billables, what advice would you give to junior lawyers struggling to balance doing good legal work with hitting their billable target? And Georgia Carroll, we might start with you.
So this is probably the part that I found the hardest when transitioning into being a lawyer. It's something I really struggled with, balancing doing good work with hitting my targets, with feeling like I was giving value to the clients. And it's actually something that's come up recently as well in starting up my practice and going, okay, is that justified? Do I feel comfortable in that? So it's something that's at the forefront of my mind at the moment. As a junior lawyer, something to keep in mind is record everything, every single minute of your day. I would record all my admin tasks, everything, so that one, you can justify why you're there, why you're a seat in the office, but two, because there's a very high chance that what you're doing will be written off or written down, and that's not necessarily because your work is bad, but because of the role you're playing at that time. And trust me, we all go through it. You don't want to end up in a position where you're double discounting your work. So if you have spent 2 hours on a letter and you go, oh, geez, it's only 3 pages, but you legitimately spent 2 hours on it because you've cross-checked it with all the other things and that's how long it's taken you, put a really good time entry in, put it in at the 2 hours, and then mark it in your to-do list or something to have that conversation with your supervisor to say, this is why it took that long. It'll probably still get written down, but if you'd already halved that down to 1 and then they halve it again, you're going to end up with nothing. So I think it's really important that you don't do the discounting at this stage. Secondly, keep a track of what is written down so that you can work on perhaps areas of improvement. If you find that there's a certain trend with things that are getting written down, perhaps that's something that you need to work on or discuss how you can do more efficiently, or discuss whether that's something you should maybe be delegating to someone else. So a lot of us start as a kind of paralegal secretary role and transition into being a lawyer, and that's a really hard change because you go from preparing cost agreements and initial letters that might not be charged for and all of that into that lawyer role. And you might come out of an initial meeting sitting in with the partner or something, and they say to you, hey, can you prepare that suite of things to get the ball rolling? And you go, yep, sure. And because you've always done it, you go and do it. And it might only take you 20 minutes, but it's 20 minutes. But they haven't necessarily actually meant that that's for you to do. But because you've done it all along, or because they've told you that you should do it, you go and do that work. And that's time that's eating into other parts of your day. So have a think about your practice and the areas that you can delegate if you have support staff to do that work for you, particularly things that go into that non-billable realm. The other thing is when you become more senior, and sorry, the only thing that will help you with this is time, but when you become more senior and have more carriage of your own matters, I found there was certainly a correlation there with being able to be a little bit more in control of my budget and billables, because I could track it more and I could track where things are up to and ensure that certain things were billed at certain times. On the question of when having the discussions with clients, really briefly, because I know the girls are going to touch on this, but transparency is key. Be upfront. If something is going to cost extra or outside the scope, be upfront about that. I mean, we have an obligation to anyway, but give them the explanation, because sometimes people won't realize that taking that extra step or doing that extra phone call will cost that extra money. The other thing that I do is actually give all my clients tips at the outset on how they can keep legal costs down, whether they, take that on board or not, it's a matter for them. But I always say, look, instead of sending me 10 emails a day, pop it all in one at the end of the day, if you can wait that long, and send it in the one hit. So I'm not reading unit per email. I'm just reading the one chunk, which might be a lot less time. So I always try and give that advice to my clients, and I feel like they appreciate that.
And I think on that point, sometimes because we don't want to do this stuff, we put it to the bottom of the to-do list and then we never get around to it. Any way that you can sort of create shortcuts for yourself. So I remember if a bill did blow out, I had sort of like a precedent wording of what I would say in the email when we sent the invoice, like X, Y, Z. These are the 3 reasons why your bill was higher than what we expected it was. And because I knew I had that wording, it meant that I didn't put off sending the invoice. And that's the worst thing, when you send an invoice that's several days old and they think, oh, why am I just getting it now? Or why is it so big? So any shortcuts that you can find for yourself to make it easier, definitely do that. Okay, Georgia, over to you.
Thanks, Dina. I have a confession, which is that I don't hate billing. I don't know if that's, I've been trying to think about it since we were talking about it the other day. I did start my early practice years. I had a really large legal aid load, which is a really different billing style. I did track my time, I billed my time, but it was against legal aid grants. So maybe, I don't know, was I jaded enough by the time that I was wholly billing private clients? Maybe that's part of the reason, I don't know. But the reason I maybe like it's going to fit, but the reason I tolerate it at minimum is that it's accountable. You're accountable to yourself, you're accountable to the partners, you're accountable to the clients, and I enjoy that transparency. So advice number 1, don't be scared of it. Lean into it as a tool to show your worth and to keep yourself on track. To do that, advice 2, develop good habits early. You will thank yourself in the years and years of your practice to come, and so will everyone that you work with. So whether that's having your timesheet open always, I have good days and bad days, but fundamentally, I always have my timesheet open and I enter my time as I go. And I cannot tell you how much different that makes to me and the people who like to chase me when they need to know that my time is in. And it means that it isn't that laborious task of, at the end of the day, I know I've sat at my desk all day, but my timesheet doesn't show it. That is an awful feeling, particularly as a junior lawyer when you're trying to demonstrate that you are, as well as very good at your job, you're commercially viable. So do yourself that favor, get into the habits, and they really do become second nature.
I guess it's that good hygiene of doing it every day, making yourself do it. Because the worst thing is if you've recorded time on a file and then the supervising partner has generated an invoice and say that you're sitting on that one particular entry, you might have missed the boat to get it on the bill. And that's not a good look, if you're charging time on the next bill. But yes. Okay. So Emma, do you have anything to add to this question?
Just on the topic of like feeling comfortable with billings, as a junior lawyer, just remember that you probably don't have final sign off on the bill. So again, use that to take some of the pressure off yourself. If you've put down your time, and don't worry too much about how much it should be cut down or anything like that, because there'll be someone more senior that's doing it and they'll be making that call. So enjoy that while it lasts. That's not always your responsibility. Otherwise, in terms of just cost discussions with clients, I would just say that we don't have a crystal ball, and at the start of a matter, it's impossible to be able to say how much it will cost them to the end. But something you can do is just try and give you best estimate of what the costs will be in certain stages, because setting those client expectations in the beginning is going to be really important for making sure that your client's not going to run out of money, and also ensuring that you're not going to lose any good faith with the client by them thinking that you had undercut the prices and then were overcharging them or something like that down the track. So if you've got a client that's very difficult and you really don't want to have to sit down and give them the hard, this is what it's going to cost you conversation, this is the amount I need up front, just imagine how difficult it will be if you've already filed that interim application and then you're telling them it's going to be 20 or 30K to get them to the end of that final hearing. But if you can break it up into just certain phases, and it might be, if I file this interim application to the end of that interim application hearing, it'll be this amount. It's going to give you a smaller net that you have to keep an eye on. And what I do is at our firm, we only bill each month. But if I've given them that sort of, this is what we're building towards, and it could be a conciliation conference and mediation, it's pretty much just the next thing up ahead that I imagine is going to be there. Then if I can see that their costs have kind of gone out that month, instead of just waiting for them to get surprised by the bill at the end of the month, I might say to them, look, I know I said it was going to be about 10K to get to the end of this, but we're not actually at the conciliation conference yet. And your work in progress on the file is already at 5K. So I don't think we're going to actually be able to do it for that. Just to let you know, you've got a bill coming. It's going to be more than it's expected. It might be good to put some money into trust now, and then you're not going to have to be hit with being asked for a lot more at the end of the month. So if you just keep doing it and having those conversations, it's going to really set their expectations, and it's not going to make them as painful along the way when it's getting really to the hard stuff or the big numbers and big chunks of money are being required.
Yeah, I think it's one of those things that everyone, maybe other than Georgia Burke, doesn't struggle with. But transparency is key. And I think maybe Georgia Carroll said that before. But just keeping clients up to date with what's going on. I guess all firms are different. I think the firm that I was at, sort of every 2 weeks, you were given a pre-billing guide and sort of asked, do you want to bill this now? But I think Emma said that her firm only bills monthly. If you are in a situation like that where it's only monthly, you might want to give them sort of a bit of an estimate of where you're at and how much more money you think you're going to need. And it's always good practice to get money in trust. It's much harder when you issue an invoice and you don't have that money in trust. You have your partners down your neck, because if they see the bill and they don't like it, then why are they going to pay the money into trust? Why are they going to pay it? So it's good to be upfront and transparent and open with your clients. Right, did anyone have anything else to add on that point, or do we move on?
Thanks, Tina.
Okay, next question. So how important is it to contribute to business development and the growth of a practice? And what can a junior lawyer realistically do to maximize their influence? Let's hear from Georgia Carroll.
Christina. So this is something that I've focused on quite a lot, and my previous role was really great at fostering that in all the solicitors at the firm, all about your own personal brand. So from day one, know that whatever you do on the job, no matter what interaction you have, whether it's with a lawyer, but even internally within the firm, people remember you. So I mentioned the other day when we were having a chat about this webinar, one of my first referrals recently was from a friend of a friend who I used to play netball with 6 years ago. And this person didn't even play my team, by the way, actually. She was like a club person. And the referral came through and I literally thought it was my husband like pranking me with like a fake name because it was a very generic name. And I looked at it and went, I didn't even think that that person would remember me. So from day one, know that people are watching you. They're watching how you speak and interact with others and how you treat them. And I think that just being a decent person goes a really long way, particularly in family law. So how can you have clients? How can you get influence? Really, really hard. As a junior lawyer, I think more often than not, we're questioning our worth. Like, why am I here? I'm not good enough, all that kind of stuff. At least that was my experience. It takes a few years, 5 at least, I reckon.
I mean, I'm 10 years out, but
yeah, look, that's a fair remark. I think it's part of what makes us good at our job, though. I've been reflecting on that a lot lately and going, you know what? I think it's the perfectionist in us, and that's why we're good lawyers, because we just go, it's never good enough. Terrible trait as a human, but as a family lawyer, excellent. So I think with that, with going back to how can you get that influence? So friendships early on, legal friendships, and I mean genuine, like be genuine about it. Don't just have this like, I'm doing this so I can get a referral. That doesn't work. It never lasts. If you have genuine relationships with people, you will in turn get referrals one day, not necessarily immediately. So some of the people that you start out with, you're all graduates, paralegals, whatever, they're not going to be at that level forever. You guys are eventually going to be the specialists, the partners, the senior associates. You are going to work your way up and then become people of influence by virtue of the experience that you've had, and will be then in a position to refer out work. So the way you get those friendships, in case you're kind of not at a bigger firm or you don't have those relationships, is you join up to your local law society. That was a major factor for me when I was starting out. I felt really lost. I was the first lawyer to ever come through, like my family and all of that kind of stuff, and I just didn't know which way to turn. And that for me was a major confidence booster, and it was where I formed a lot of really fabulous relationships, and they're people that are some of my best lawyer friends today. They're people that we now have a group chat with, some who may have dialed in today, and we ask each other questions all the time. They're our referral source, they're our education source, they're our like emotional support water bottle friends. Like they are everything for us. So I think that's a really important part of the job, not to be underestimated. They will pick you up when things are down as well as one day build you that referral network. The other thing is, sorry, this is a long-winded response, but it's something I'm quite passionate about. Find what works for you. A lot of junior lawyers would come to me and say, I don't really feel comfortable doing like a video post, because that was something we were doing at the time. Not everyone loves getting in front of the camera. I do. Hello.
Here we are today.
Here we are today. But that same person might be an excellent writer. Put up a blog post that on social media. That's the way you can access and get exposure to a lot of people. Join the local law society or other committees. But even within your network locally, join sporting clubs, like just be active in your community. The last thing is just do really good work. Some of my best referrals that I can remember are from clients sending friends, families, new partners is a big one. People come back to you or send their friends and family to you when they've just had a really good experience with you. And sometimes if you're questioning, like, have I done enough business development and marketing and things like that, sometimes the best thing you can do is actually just be really good at your job.
I think just to piggyback off what you were saying, so I was a part of the Young Lawyers Family Law Subcommittee, and I know they're meeting this Monday. If anyone's interested, reach out and I can give you the
They're
link.
Looking for a chair, I think I saw in the emails.
I did see that, yeah. So I was the chair. It's a great role. It also puts you in touch with the rest of the law society. You know, that it's not just family law, there's a criminal law subdivision, civil litigation, employment law. So if you're interested in other areas of law as well, you know, it's also a great way to connect. And I think that sort of leads nicely to Georgia Berg, because I know you're quite involved with the Law Society as well.
Yes, so it feels like we're treading some similar ground here, but my advice is to diversify your networks. So whether it is the sporting clubs, as Georgia Carroll has said, or joining law society committees other than the family law committee, great to be involved in as well. But one of the things I absolutely love about being on the diversity and inclusion committee is that I'm interacting with lawyers from other practice areas that I just wouldn't otherwise. And what that means is that from time to time, I'm the one family lawyer that the employment lawyer knows, or that the criminal lawyer knows, or someone working in-house at TAFE, for example, knows. And it's a great way to be in the mind of those people, as well as developing the breadth of your practice and your knowledge as a practitioner and a contributor to the legal community.
Great, thanks for that. Emma, we might turn to you now.
I'll just say that a lot of the comments so far have been really geared at ways that you can grow practices by introducing clients. But don't forget that you can contribute to the growth of a practice in other ways. So all those connections that the girls have mentioned before, it's also a way to meet other lawyers. And it might be that your firm at one point in the future is looking for a junior lawyer or looking for an associate, a senior associate. And you might be able to make that introduction and do the wooing that eventually results in that person joining your firm. And that's another way that you can contribute to the growth of the firm and in the partner's eyes be seen to be valuable. And it's the same sort of thing with experts. Going to those sort of events, you will meet the valuers and the single experts, that the accountants, the property valuers, all those sort of ones that we use all the time. And a lot of those expert witnesses are very open to coming to firms and doing presentations because it's their way of marketing themselves, and it will put them in the minds of the lawyers at that firm to be nominated when they're putting forward potential experts for a matter. So that's another way that you're going to be assisting the business development of your firm and the education of the lawyers there will be by getting those sort of experts in to be able to give that sort of expert knowledge to the staff. And if you've been that facilitator that's gotten that expert in, you've probably been able to speak with them on the phone or do some emails, and it might develop a relationship where you get to the point where you might be able to just pick up the phone and just ask a stupid hypothetical question and get an answer that might help you. So yeah, just remember that there is a really vast way that you can be a valuable contributor in terms of firm growth.
And I think sort of business development, I also think I guess firm culture is really important in that, and it sort of piggybacks off what you were saying, Emma. But if your firm is known to be a nice place to work, you'll have more people want to come and join it. And if you're part of it, making it a nice place to work, like I remember organising social events for the team, and it was just a great way to bond, but also, like, I guess, strengthen the firm as well. So I think that's also good too. All right, so moving on to the next question, which I think is a really important question as well. So those early years, we all know, can feel very intense. How do you manage competing demands, times, deadlines, court dates, and keep things running smoothly? And are there any systems or routines that made your day-to-day work more manageable in those early years? George Burke, we might hear from you first.
Yes, systems, absolute key to managing stress in the early years and always. When we were talking about this the other day, it really brought back that feeling I had at about 8 months of practice, where I felt like I had to hold everything, every date, every next task I needed to do in my head. And that is incredibly stressful, particularly if you have any kind of size of file load. And it was a turning point for me when I realized it was my systems that I needed to get under control, and that if I could trust my systems and put the work into the systems, it really eased my stress. So it's finding what works for you. I, in my early years, used the task resubmit function in Outlook. That was my lifeline. It captured everything that I had coming up, every court date, every subpoena returnable date. And so I knew that that was something that I could check every day without having to rely on my independent memory. in those 10 years, of course, great tools have been developed. We use some other systems here now, electronic task keeping systems that are really, really helpful. But play around with it and find what works for you. Sometimes it's a combination. Sometimes a good old pen and paper also doesn't go astray, as well as the more modern ways we have to manage these things. But the other aspect there is also your PA. If you're lucky enough to have a PA that works for you, whether that's with someone else or you have access to part of your firm's pooled PA support, they are invaluable. One of the best pieces of advice I got on the eve of being admitted as a lawyer was that your PA is gold. They should know more than you about, if not the content of the law, that's on you, but how your practice is running. So keeping them across your matters, involving them, getting to know them and letting them get to know you. So if they know your learning style, if they know your work style, then they're going to be there to assist you the best that they can. So put into that relationship, invest in it. It's really important. They really know their stuff.
Emma, we might just quickly hear from you on this point as well.
I would just say, in terms of keeping things running smoothly, I think you've just got to accept that it's never going to run smoothly. It's that sort of area of law where you don't know what's going to happen on that day and what urgent things would pop up. But what I would do to try and keep my anxiety levels at a functioning level would be, I would do welfare checks on my matters. So it might be at the start of the week or twice a week, just, you know, that 10 minutes before I get going for the day, I would write a list and then highlight what the most urgent tasks are. So I just kind of try and turn my mind to each of my matters and what's the next thing that's happening in it. And then it would jump out at me, like what are the most urgent things that need to be done. But there will be, like I was saying, there will be things that will be popping up, and you might have a client that's ringing you non-stop for 2 hours, and you just don't have time to deal with them. You don't have time to answer the call. They freak out all the time, and you know it's probably something that's not urgent. But even if you don't have that 10 minutes to have that conversation with them, if you do sometimes just pick up the phone and just have a 2-minute conversation with them, it can be enough that it's going to make what they think is an urgent issue no longer very urgent. A lot of the times clients spiral just because they don't understand what the next step will be. And even if you don't have time to deal with that issue in detail or actually do a letter about it, just simply telling them that I don't have the time to do it, but we will do a letter. It will address X, Y, and Z. Just knowing that that's the next step will be enough that they'll be calm for the next few days, because it's taken that uncertainty away from them, and it will then give you that additional time that you needed to be able to get that done. So yeah, I think you've got to just triage your matters, and sometimes just touching base with the client you don't have time for might give you the more time that you need and give them that peace of mind.
Great, thank you. Next question, how is technology changing the way you practice, and what tools do you recommend young lawyers get comfortable with? Emma, we might go back to you on this point.
Well, the whole form of family law looks very different to the way it did when we first started out. I'd go back to what I was saying about the core skills. I wouldn't be too reliant on technology until you've got the basics down, because otherwise you're going to miss out on that learning curve, and you're going to be put in a position someday where you're not going to have those technology devices to rely upon, and you're going to look the fool. So I would use your brain and do a lot of the manual old school style until you've got all the basics down, and then you can utilize those things to sort of assist you. Otherwise, it would kind of building on what Georgia Burke was saying about getting your systems right. There is a lot of technology that you can utilize for that. Like now we do a lot of things electronically, like indexing. But my number one tip would be just get organized in terms of disclosure. If you've got a good filing system for your disclosure documents, it's just going to make that matter run better, because you're not going to look silly by asking for documents you've already got. It's going to make doing balance sheets and things like that more enjoyable for you, because everything's going to be at a touch of a hand. You're not going to have to dig through it. And it's just one of the most important things to do from the very start of a file.
And just on that point, so LEAP does have so many functions that you can use that sort of will, I guess, take a lot of the work out of things, but you have to know how to do things right before you can depend on those systems. I mean, there are so many cases now going through, you know, the FCFCOA, and in different jurisdictions in the states where practitioners have just relied blindly on AI, and that's not something that you can do. I mean, even in my own experience, I've used AI and it hallucinated that there was a referendum in 1974 about the Family Law Act, and when I asked AI, "Did you lie to me just then?" it said, "Yes, sorry." So you have to double check everything. But yeah, I mean, we have Balance Sheet Plus, or we have the parenting calendar, and these are all tools that I think you should take some time to familiarize yourself with, but learn the basics first. And I think when we were talking about, as Georgia Carroll said, also do everything by hand. The amount of times where I would use an Excel spreadsheet and there were hidden formulas, if you're not double checking those figures, you're not going to pick up on that. So that's really important as well. And with that, I might move to the final question, which is a bit more of a light question, but what's the best piece of professional advice that you've ever received and who gave it to you? So Emma, we might start with you again on that one.
I can't remember who gave me this advice, but it was someone early in my career, and they said that my practicing certificate and my reputation is more important than impressing a client. And what they meant by that is that clients are going to come and go, but you'll be in this profession for a long time, and you'll have the relationships with the judges on the bench and the other solicitors in the profession for a lot longer than you will with that individual client. So if you've got a really nasty client that's trying to bully you into doing something that you don't feel is appropriate, and it could be, I want you to get up in front of the judge and I want you to yell, I want you to get really angry, just something that's just not appropriate. Just don't feel pushed into that, because at the end of the day, impressing that client is not going to be something that's going to matter to the long term of your career. And you'll never know who in the profession you're going to need a favor from at some point, or who you might be asking to employ you or anything like that. So always put your ethics and your practicing certificate and your professional reputation above any individual client sort of demands or trying to impress them.
Great, thank you. Georgia Burke, over to you.
One of my dear early mentors said to me in my early years of practice, something that I've remembered forever and try and keep up to this day, and that's to read and digest information widely and be beyond your bubble. As family lawyers, we're working with our clients who come from all walks of life, all political persuasions, and it is important that we know what's going on in their lives to best be able to assist them, to understand what might be impacting their parenting style, to understand what might be facing their business. So it's something that I've taken heed of, and I try to continue. So that's my piece of advice.
Great advice. Georgia Carroll?
I love that one, Georgia. It reminds me of something that the chancellor at my uni graduation said, David Gonski. He said, as you become more niche and specialized in your field, it's so easy to become narrow-minded. So always think more broadly and actively make endeavors to be broad. And as you said, in family law, it's so important because you are dealing with such a broad part of society. Mine is... my tip or best piece of advice was from a former partner that I used to work for. He said to me when I was grappling with how to juggle being a parent, being, a daughter, this, that, the other, trying to do my best at work, was just to be present wherever your feet are. And it's so simple, but it's really stuck with me. It's like you just focus on whatever's in front of you, and that's what you can control in that moment, and do your best work with what's in front of you. If you're with your kids, have your phone away, that kind of approach. So it's something that I try really hard to do. Sometimes well, sometimes not so well, but if I could follow that advice, it would be quite life-changing, I think.
So it's all been good reminders of the good advice we've had over the time that we can try and check in on ourselves.
I think the only thing I would say as well is sort of remember that you are a person outside of your work. I think in this line of work, we often sort of wrap ourselves up in our work and our value as I'm a person sitting in a seat and I can build this many hours. if you tie your self-worth into that, that's going to be very negative, and it will take you a lot of work to get out of that. So just keep that in mind. And with that, I will conclude the webinar. Thank you so much to our presenters. I know I even learned a lot from that, so I'll take away a lot as well. And just a thank you to our forum members for dialing in. As I said at the start of the webinar, if you're not a forum member, please use the link that I've shared in the chat box to go and register, and you'll get advanced info of the webinars we've got on and the content we have. We do have another webinar that's scheduled in 2 weeks' time on the 15th of October. So we'll be hearing from Alicia Elliott from Broome Abrahams Burrigot, and a special guest that we're not yet able to announce about returning to work after having a period of leave. We look forward to see you all then, and thank you again to our presenters. Thank you.